Call the next case, 118894, State of Kansas versus Michael Allen Keyes.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Michael Keyes, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a first-degree murder prosecution out of Grant County. My client was accused of, and in fact admitted, shooting and killing the decedent in this case, although he claimed that it was self-defense. But despite his claim and evidence of self-defense, the district court in this case refused to give a self-defense instruction, and that is our lead issue in this case. Your Honor, at the outset I will acknowledge, of course, that there are competing narratives in this case, and my colleague has, I think, done a really good job of sort of outlining the state's evidence in this case. But because in both issues in this case, the instructions were requested by the defendant, the standard of review is in a light most favorable to my client. And by the way, I don't know if this is dancing on the head of pins or not, but what? Because remember, when we were using that standard of review, when we're doing, for example, a sufficiency analysis, it's viewed in a light most favorable to the state. Is there evidence which would support a reasonable fact finder finding the facts beyond a reasonable doubt? And I just would remind us that that's not what I have to show as a defendant, right? I don't have to prove anything. So the standard review here is viewed in a light most favorable to the defendant. Is there evidence on which a reasonable juror could form a reasonable doubt? I don't have to prove anything beyond a reasonable doubt. So I don't know what that quantum of evidence is for a sufficiency issue, but whatever it is, it's less for what I'm talking about today. And we're doing it in a light most favorable to my client. So of course I'm talking about the facts in that light. Knowing that there are other facts out there. But the basic narrative from my client was that the decedent in this case, Jimmy Martin, had acted violently, maybe even the day of the incident in this case, and that Jimmy Martin was living in a house owned by my client's girlfriend, a trailer in this sort of area, and that they decided he no longer needed to live there. And my client went over to tell him to leave, maybe even force him to leave. And that then things got violent, and my client defended himself.
Is there any factual scenario in which your client isn't the initial aggressor?
Sure.
I just don't see it. He enters the house, and he enters with the intent of provoking or at least doing something to the decedent. How is he not the initial it doesn't initially at least provoke the altercation?
It's not, well.
And I understand there's different fact scenarios from that point, but initially, isn't that what occurred?
Okay, so first of all, I want to be clear. The Judge Peterson didn't find he was an initial aggressor. He found he was a forcible felon. And that was the reason that Judge Peterson didn't give the instruction in this case. And so I want to answer your question, but I want to come back to be sure to address what Judge Peterson did in this case. But certainly, it is not necessarily, and it's not my client's testimony that he went over necessarily to engage in a fight or something like that. Now, given Mr. Martin's violent tendencies, my client understood that it could escalate into that. But there's no showing from my client's testimony that it's undisputed that he went over there intending to be violent, that he went over prepared. Now, I don't think every law enforcement officer that executes a warrant and is carrying a gun into a house is an initial aggressor, Your Honor. I think they're prepared to deal with violence, but I don't think they intend to go in hoping to engage in violence. And similarly, there's no showing on the record of my client intending to go in there to commit violence just because he happened to be armed to protect himself as he needed to do under his narrative. Judge Peterson found that Mr. Keyes was not entitled to a self-defense instruction because he was a forcible felon, specifically that he committed burglary by going to the house. Judge Peterson compared this situation to somebody breaking into his house and then the homeowner using proper self-defense, and then, as we know, under the law, a person doesn't get to use self-defense if they are the burglar in that case. In order for Judge Peterson to be right, two things would have to be true as a matter of law. My client would have to be unauthorized to go into the house, and my client would have had to have gone in with the intent to commit a felony or a theft or a sexual battery. And as a matter of law, we're arguing that as a matter of law, actually it's the opposite, especially with regard to the authorization, that there's nothing in this record that shows that my client wasn't authorized to go into this house. There is no evidence regarding any sort of property interest on the part of the decedent in this case. There is a showing that my client let him live in this trailer. And so as I indicated in my brief, I think there's some showing of some sort of a possessory interest, I guess, that he's at least a long-term guest in her house. But there's certainly no showing that he had such an interest in that trailer house that he could exclude the rightful owner of that house or other people from being in that house. And because of that, really as a matter of law, there's no showing that he was not authorized to be there. He's unauthorized to be there. Now, my colleague notes that there's not a lot of evidence here, and I would respond two ways to that. One, it's not our burden to show that the exception applies in this case. And two, I don't think it's surprising that there's not a lot of evidence about this because nobody even thought about this, I think, according to the record, until the judge brought this up at the instructions conference. Everybody in this whole case was going along the whole time thinking this was a self-defense case. At pretrial, at voir dire, during the case, everybody thought this was a self-defense case, and then suddenly it wasn't. So it's maybe not surprising that we don't have a lot of evidence in that regard. Although the evidence that we do have is that this trailer belonged to my client's girlfriend and not to Mr. Martin.
Is it true that, my thinking here is that if the tables had been turned and the victim had killed Mr. Keyes inside the trailer, wouldn't the law have presumed his actions were reasonable as self-defense?
That he, under the presumption that you're entitled to, like, stand your ground.
Right.
Maybe.
How in the world can you have it both ways?
Because it can go both ways. Let's say, for example, my wife's on vacation, and I don't know that she came home early, and she's breaking in but she lost her key, but she wants to surprise me, so she's coming in the back door that I think is all these kind of things, and I shoot her and kill her, right? She's entitled to come in the house. I use self-defense against her. She might use self-defense against me when I'm using self-defense against her, thinking I'm not supposed to be there. It's in the state of the mind of the person using the force that we do this judgment of the self-defense. And so it can go both ways. It could be that both parties are acting in self-defense lawfully. I'm just trying to think, could they even be presumed? What if it was my wife and I in our own house, not knowing it was our wife and I? And maybe we could both be presumed to be using self-defense.
But in this case, we had one person having night goggles, the defendant. In your example with your wife, if she came in, or our example, if one of you had night goggles, that would make it different. As far as self-defense.
Yeah,
defense.
Your Honor, that's part of the state's evidence, not my client's evidence.
No, but I'm just saying, isn't that part of the facts that this particular defendant came into the trailer with night goggles?
That's the state's evidence, not my client's evidence.
Okay.
That's not undisputed.
Okay.
Your client testified he didn't wear goggles. Is that right, or you don't know?
I don't remember. My client testified it was dark and he couldn't see a lot of things. So I'd have to review it in more detail. But
let's assume that it was error not to give the instruction. Based on this discussion of the evidence,
The self-defense.
why isn't it harmless?
I appreciate the opportunity to sort of argue. First of all, and I know the law is against me on this, but I have a hard time understanding to the extent, particularly for this kind of an instruction, because this is a defense instruction. So I think the failure to give this instruction is constitutional error. So I think in order to find this harmless, you have to find beyond a reasonable doubt that it could have had no impact on the case. And I don't understand analytically, just in general, to answer your question, I don't understand analytically how you can say there's evidence on which a reasonable juror could find the defense, but beyond a reasonable doubt, no juror could have found this beyond. So analytically, I've kind of been questioning that ever since this court kind of has applied harmless error, at least to a constitutional instruction error. But putting that aside and trying to answer your question more directly, but there's a ton. I mean, I admit that there's a different narrative on the part of the state here, but there's extremely strongly contested narratives in this case. There's a lot of evidence supporting my client's narrative and his story that Mr. Martin was violent repeatedly, that he had threatened people with knives before, even in the days before this incident, and that would justify a jury forming a reasonable doubt that my client was acting in self-defense. That I don't know how you get to beyond a reasonable doubt. A jury could never have formed that reasonable doubt. And that's what you have to find a harmless in this case.
If we apply the non-constitutional harmless error test?
I think it's still harmful error in that case. I think it's hard. But again, with the strongly competing narratives in this case, I don't even know. I mean, Mr. Keys is entitled to a defense. That's a constitutional right. And so
your argument on the constitutional error here is you have the constitutional right to present your theory of defense. This was his theory of defense. He wasn't allowed to do it.
He wasn't allowed to do it. So I'm stammering a little bit because I'm like, that's a constitutional error. I'm not being able to present my lawful defense. But even if I'm wrong, as I often am, again, because of the strongly competing narratives in this case and the strong evidence of the violent tendencies of Jimmy Martin, and all I have to show, even if I'm on non-constitutional error, is that it's more likely than not that a juror, one or more jurors, might have formed a reasonable doubt. That's all I have to show, Your Honor. And I think the record in this case more than supports that kind of a finding from this court. Your Honor, my time is short, and the second issue is similarly factual. I will answer questions, but otherwise I will submit that issue on the brief.
Other questions?
Thank you, Your Honor.
counsel.
May it please the court, my name is Jessica Akers and I am here on behalf of the state. I'm the Grant County attorney. I'm just going to piggyback off of where my colleague left off with the, I would disagree that there is strong evidence from the defendant that he has a self-defense argument in this case. The only thing we really have is his testimony at trial. That was the first time that we heard the discussion or the testimony about this supposed fight that occurred in the victim's room. When he was first interviewed by the KBI, he claimed that he didn't know where the defendant was, that he'd been helping look for him. It wasn't until the second interview with the KBI that the defendant admitted that, yes, he shot him 4 times, twice in the head and twice in the heart. Then at trial, we have a third story where the defendant claims he went in there, he was under instructions to kick him out. It's the state's position that the instructions were to kill him, not to kick him out based on the purchase by the homeowner herself of a similar plastic that the victim was found wrapped in approximately a month after he was murdered. There was no testimony by the homeowner that she had given him these instructions to go and forcibly remove him. She was there herself
But
that morning.
Are you conceding that some evidence was presented?
Just from the defendant himself.
And why isn't that enough?
Because in light of all of the evidence, I believe it's the Rudder case, says that the defendant is generally allowed an instruction for self-defense. Even if that evidence is slight or trivial, his own statement is enough for that. However, I believe it's Rudder also that says it's not enough if there's other evidence that overwhelms, or maybe that's not the right word, but if there's other evidence to discount the defendant's own statement that a self-defense instruction does not need to be given.
It pretty much has to rule out the plausibility, doesn't it?
in order for that to apply?
Yes, I would agree, and I would
And how
submit.
does your evidence rule it out as opposed to compete with it?
I would submit that in this case, the testimony by the pathologist, Dr. Hossein, when he did the autopsy, he stated that while he could not acknowledge or state which shot was first, whether it was the chest or the head shot, he did state that the shots to the chest severed the aorta. He also stated that the shots to the head would render him basically incapable of, he would be dead within seconds. The statement by the defendant was that he went in, the victim lunged at him with a knife, a scuffle ensued, and he shot him in the chest twice. The victim got up off the bed, came back at him with the knife, slashed at him, and then he had no choice but to shoot him in the head.
Excuse me, was the knife ever recovered?
There was a knife that was recovered, and I apologize, I can't remember if it was collected as evidence. It was in the photographs that the state used at trial. But the knife was found on the bedside table, partially in its sheath or scabbard, I'm not particularly sure of the word, partially in the sheath next to the victim's glasses, next to a cup, an ashtray, and a photo album, I believe, that was on top of the cup. The state asked the defendant whether he had moved the knife. He said he never touched it. So based on that total factual situation, it's the state's position that it's physically impossible for the defendant's version of events at trial to have occurred.
Let me just make sure we're clear. So you're saying that the pathologist couldn't order the shots, couldn't decide whether he was shot in the chest or shot in the head first.
That's correct.
What about whether the 2 shots to the chest and the 2 shots to the head were together? Any kind of timing on those from the pathologist?
I can't recall based on my recollection of the record.
Just, that was a nuance that I didn't know whether you'd be able to answer, so no concerns. The other thing is, what I understood you to say just a moment ago was that the 2 shots to the head would have been immediately disabling. What about the 2 shots to the chest? Did the pathologist testify that the 2 shots to the chest would have killed him virtually instantly?
Yes, Your Honor.
Okay, thank you.
And the state specifically asked, and I believe it is in the record, that what the aorta is, what its function is. And I asked the pathologist at trial if the defendant had claimed that the victim had been shot, got up again, came at him, and then he had to shoot him again, if that was a plausible story. And according to the pathologist, he said no.
Okay,
But
thank
when
you.
you've mentioned twice that he said he got up after being shot. And my understanding was the defendant's testimony was that he grabbed the knife, got up, slashing it, and that's when he started to shoot. So that the defendant is saying he was already up, he shot him, and then he was continuing toward him, and he shot him again.
That's not my recollection of the...
Okay.
But it has been a while since I've read the whole
Can you address
transcript.
Mr. Hodgkinson's point regarding that the instruction was denied because Mr. Keys was committing a burglary?
I cannot discount that, or I guess
Wasn't
I
that the
agree.
reason that the district court made for denying the self-defense? It didn't have anything to do with the plausibility or that. It was just the simple analysis that he was not authorized to be there. You can't assert a self-defense when you're not authorized to be in the premises in the first place.
That's correct.
Is that how he ruled?
That's my understanding. My recollection of the events. The state didn't even get an opportunity to argue regarding that specific instruction. It was just between Judge Peterson and defense counsel. And Judge Peterson did, if I recall correctly, say that he found that it was Jimmy's place, the victim's place. Defense counsel claimed that it was not, and Judge Peterson said that based on the evidence he found that.
So what we're looking at either in a harmless analysis or whether the propriety of the plausibility of Mr. Keys's explanation didn't really that wasn't analyzed by the district court at the jury instruction. The district court just ruled it out because it was a burglary.
I don't know if he specifically said burglary, but yes, there.
He was unauthorized to be there. In
Yes.
essence, you're limited to arguing the district judge was right for the wrong reason, or potentially the wrong reason.
And I guess more eloquently said, yes, Your Honor.
Well, succinctly, maybe not.
Okay. And I mean, I guess I can just kind of jump on my argument for the harmless error standard. I would just, based on, I guess, the plausibility of this story from the defendant, that it would be harmless error if this court does find that the self-defense instruction should have been given because of the totality of the evidence presented.
Let me ask you something.
Yes, ma'am.
Again, real quick here, following up on my colleague, Judge Lieben. If the story of the defendant is as he recalls it, which is frankly the way I recall it as well, that deviates in a pretty significant way from what you described the evidence. If the defense testimony was that the victim was up out of bed, slashing around with a knife or making slashing motions with the knife before the first shots were fired, that undercuts your implausibility argument about not being able to rise from the bed because 2 shots had already essentially disabled him. I mean, that at least competes with that, correct?
I would, yes, competes with that.
Okay.
Again, I don't recall.
But
the
that was a pretty
specifics.
significant piece of your implausibility argument.
I still think that the implausibility argument stands,
Okay.
Your Honor, because of where the bullets went into the chest, it severed the aorta. I mean, Dr. Hossein testified that while a death wouldn't be just that quick, there was no ability for him to continue on with movement, with actual movement.
Okay, thank you.
Counsel, I had a question about Carlo Malone.
Yes, sir.
Would you agree that was a pretty important witness at the trial?
Absolutely.
The one thing that I'm unable to reconcile when I think about harmless error with respect to that witness, we know for an absolute fact there were 4 shots fired.
Yes.
And Mr. Malone claims to have been there,
Yes.
and that's key to the case you presented to the jury. And he told the officers when he was interviewed he only heard 1 gunshot. And then at trial he reconfirmed, you told the officer that you only heard 1 gunshot, yes. Then you took off running, no. He told me he had some cleaning up to do, so get out of here. And then asked again, and you only heard 1 gunshot, yes. So he's very clear both in talking to the KBI and at trial, I only heard 1 gunshot, which seems to cast some doubt about whether he really was there or whether he made up a story to try to get some benefit from the state. So I'd like you to address that in terms of the harmless error question.
Yes, Your Honor. I think that, one, I don't think that Carlo Malone made up the story. He also testified that he was very close with the victim. He essentially raised him. It was his stepfather, but he essentially raised him. I think that the fact that he said 1 gunshot throughout from the beginning to trial, and probably if you asked him today, he'd still probably say 1 gunshot, supports his credibility. I mean, I know you all do not reweigh credibility of witnesses, but I think it goes to the fact that he says this, that the defendant claimed he had some cleaning up to do, which is exactly what he did. He wrapped the body up in plastic sheeting, and then Carlo came back and helped him load it up. I don't know, and there was no evidence or testimony by expert witnesses, but I would just, for argument here, I mean, I don't know what I would do if I heard my stepfather get shot. And, he was also very scared of the defendant. He also testified, I believe, that the defendant came to the trailer he was in. He had a gun with him. He forced him to walk down there. He told him to stand by the back door, to not let anyone out. So from the beginning, he was nervous, scared, and intimidated. So I think all of that can factor into what he heard that day.
But all of that is about his emotional state, and it's not about the basic conflict between the immutable physical evidence of 4 shots being fired and his consistent testimony that only 1 was fired, or that he heard only 1. So I understand that there's certainly the ability on this record to have a sympathetic portrayal of his emotional upset at the time for a variety of reasons, whether he felt threatened by the defendant or very fond of the victim because of their history. He still said one shot, and I think that's what my colleague is getting at. To the extent that you are critical of the defense case as inconsistent with the physical evidence, you're forced to admit, are you not, that the story from Mr. Malone is also inconsistent with the physical evidence.
In the sense that there were actually 4 gunshots and he testified to one, yes. And I apologize, I didn't answer your question better. So.
I think you did fine. I just wanted to point out what he was really trying to get at. Okay.
What kind of weapon was used?
It was a gun, and one was not recovered.
Was it .22 caliber?
I believe so, but that may have to be something that was in the record. I know that bullets were recovered during the autopsy, and I apologize, sir, I can't recall exactly what caliber they were.
Other questions? Thank you, counsel.
Thank you, Your Honor.
Your Honor, I just wanted to respond to Justice Rosen's question because I wasn't ready for it on, about initial aggressor, and I had to look it up, and in part because this really wasn't raised below.
Right.
And, under 2152, 26B, which, by the way, do you like these that I got for my 50th birthday? It says, you don't get self-defense if you initially provoke the use of any force with the intent to use such force as an excuse to inflict bodily harm on the assailant. And there's that specific intent aspect of that. That's a fact question. I mean, to the extent that you think there is evidence of that, the proper remedy for the district court is not to cut off a self-defense, but to give a self-defense and give an initial aggressor instruction. That this should be the decision of the jury. Your Honor, I think I've raised a lot of sufficiency issues in the past, and I understand the standard of review when I do that. I even teach about it. It's difficult, and I understand that most of the time when I raise those sufficiency issues, I'm going to get a decision from the court saying we don't reweigh the evidence of witnesses. We rely on juries who see the witnesses face to face to decide the credibility of witnesses, and we're not going to redo the jury's job. Your Honor, I just want to point out to you, I thought it was interesting, just listening to you all talk to my colleague, sounded like jury deliberations to me. Well, what about this? What about the inconsistency between these witnesses? What about this part of the facts? And, Your Honor, it seems to me that before the state gets to essentially sentence my client to death in prison, which is effectively what happened in this case, he was entitled, and he is entitled, to have a jury make those determinations, a jury of 12 people in Grant County. And that's all we're asking for. These are all arguments that my colleague will, and I'm sure will make if you resend this case down to back for trial. But that's where it should happen. That's what we're asking for in this case. Thank you.
Thank you. Court will take this matter under advisement. Thank you.